I'm told that might happen, and they've got a burning question that they want to ask. There's another function, there's a little hand on the toolbar. If you raise your hand, then we'll work out some way for you to ask your question. So thank you. There's a couple of people who've just joined with their video on. If you could turn your video off and go on to mute, that would be great. I think is it Craig Cut? Yeah, thank you, Craig. And I've still got a bit of background noise, so everyone, please. Someone, thank you, whoever that was. Okay, I'll get started. I just wanted to introduce the panel. As I said, we've got a very impressive panel with deep arbitration experience, and I'll just introduce them briefly in no particular order. Starting with Jonathan Redwood. Jonathan, if you want to just, your name's there. Jonathan's a member of Banco Chambers and List A Barristers. He's also a member of Maxwell 42 Chambers in Singapore, and he's of course the Vice President of ACICA. He regularly appears throughout Australia in the areas of commercial law, class actions, regulatory proceedings and international arbitrations. And he's appeared for ACICA in the High Court cases of Westport, TCL Air Conditioner and Reinhardt, cases we're all aware of. He's also acted in large international arbitrations seated in Australia, Singapore, London and Milan. He holds a master's degree in law from Harvard and Oxford and was a fellow at the Lauder Park Centre for International Law, Cambridge in 2012. So thank you, Jonathan, for speaking today. Our next speaker, Beverly Newbold. Beverly is the head of Minter Ellison's Dispute Resolution Group in Sydney. Her practice is a mix of domestic and cross-border litigation and international arbitration. During her time at Minters and previously at Freshfields, she has conducted international commercial arbitrations across a wide range of industries, including aviation, financial services, telecommunications, manufacturing and IT. Those arbitrations seated predominantly in Sydney and London. She holds a master's degree in international business regulation, litigation and arbitration from the New York University. The third speaker, Andrew Battison. Andrew is the head of Norton Rose Fulbright's international arbitration practice in Australia. He practices across the Asia Pacific, India and Europe, and he specialises in international commercial and investment treaty arbitration. He acts as counsel to a range of clients in arbitration under all the major arbitral rules. Andrew also sits as arbitrator in disputes involving a wide variety of parties, laws and industry sectors. He has particular experience of disputes in the energy and resources, finance, fintech, construction and infrastructure sectors, as well as undertaking general commercial disputes. He's acted in disputes under both national laws and international law worldwide. He's an active member of the international arbitration community. He's an Australian delegate to the ICC Commission on Arbitration and ADR and serves on the SEAC Users Council. He holds a BCL from Oxford. So thank you all for speaking today. I'm sure everyone attending will agree it's a very impressive panel. Our topic today is arbitration of force majeure, frustration of contracts and MAE provisions. Very, very topical. Certainly from my perspective, I've been asked more about force majeure and frustration over the last 6 months than I have over a large number of years. So it is an issue that is floating around due to the COVID situation. I'll just give a little bit of an outline of the general structure before we leap into it. I won't take up too much more time, but we were going to have the speakers outline the general concepts of MAE provisions, force majeure, frustration, and then we're going to talk about where we're seeing things, these issues arise, and then swing to a more of just the international arbitration perspective on these issues and these types of disputes. So, as I said, if you have questions, feed them into the chat, and I'll try to raise them as the discussion unfolds. But maybe, Jonathan, if we start with you on MAE provisions, would you like to give just a little bit of a snapshot on what these provisions are and how they operate to set the context?
Sure. Thanks, Jeremy, and thanks everyone for joining us today. So I'm going to talk, as Jeremy said, briefly about the basic sort of contours of material adverse effect clauses, or otherwise MAE, or sometimes called material adverse change, MAC clauses. Now, in a very general, pervasive sense, this has become very topical because we're living in a world that is more than ever perhaps defined by change, and a lot of it can be characterised in a general sense as adverse and certainly material. So it's not surprising that these type of provisions are getting a lot of attention and scrutiny, and we expect that, I think generally that's expected to continue for quite some time. So the first basic proposition is that these provisions are creatures of contract. They're not a product of some freestanding common law doctrine. And since they're a creature of contract, they come in a variety of different forms and reflect a variety of different drafting techniques. Typically, as many would know, they're one of the most heavily negotiated provisions in M&A agreements or financing arrangements. And in terms of the way they can contractually operate, they can operate across the entire anatomy of a commercial contract in terms of as a condition to closing or a condition to a party being obliged to perform. They can operate as give rise to a right to terminate, and they can also obviously qualify the effect of a representation warranty. So it's not unusual to have a representation as to X, except where it would not reasonably be expected to result in a material adverse effect. The other thing about them being a creature of contract is many of them are drafted at a general level in terms of the general impact on the financial condition of a company. However, there are many, particularly these days, examples of specific MACs, if you like, that embed within them particular contractual triggers, reference to financial covenants such as EBITDA and net assets and so on. And really what we're, at a fundamental level, what we're dealing with here is, a comparison, a temporal comparison between, if you like, financial condition as at point A versus point B. Now, in terms of the second point to make about them is there's not a lot of case law about the interpretation of these provisions, and that probably reflects the fact that engaging these provisions is high stakes for both the proponent of the clause and, if you like, the party on the other side. So what invariably will happen where it's suggested to be engaged is that there will be some process of renegotiation of the relevant contractual arrangement, such that litigation typically is avoided. The other general factor, of course, is that in a recessionary or depressed environment, one's more likely to see utilisation of these provisions, and obviously up until recently, we've been in a non-recessionary environment. Nevertheless, there are some themes and guidance that can be drawn from the Australian, English and US cases. The first is an obvious one, and that is that much depends on the particular provision and the particular facts. But generally, making out a material adverse change clause is a very high bar, requiring very specific evidence. At an overarching level, the key principle is that the proponent needs to establish that the event or series of events is significant and substantial, and that it's not ephemeral or temporary in duration. Now, there have been some cases, in the vast majority of them, the courts or the relevant, in some cases, takeover panel has said that the clause isn't made out, but equally there have been examples in both the M&A context and the lending context where it has been found that the clause has been made out. A very high-profile example was about 18 months ago. There was a very significant Delaware decision called Acorn, where in that particular circumstance there'd been an 84% drop in earnings, and the Delaware Supreme Court, which historically had been very hostile to such clauses, held that had been made out, and there have been other examples that I'll probably come to, time permitting, in the Australian context. Now, a third point to make about them is this, what one often sees in the cases or the discussion is the concept of needing to establish materiality and duration of significance. So in terms of materiality, we're really talking about a change that is severe, but not a blip. And US courts have described an adverse change as one that's consequential to the long-term earnings power of the company. And again, I just keep emphasising that this is in the context of a generally worded MAC, and that much will depend upon the particular MAC in question. In terms of the other significant point is, again, it needs to be durationally significant. So that has been described, again, by some of the cases as over a commercially reasonable period of time, measured not in months but years. So that just gives some indication of the type of temporal impact. The other point that will often come up is foreseeability, whether the alleged material adverse change was something within the contemplation of the parties at the time they executed the agreement, or whether it was in their control. And we'll talk a bit more specifically about COVID in a moment. A fourth point to make is that the distinction is usually drawn between company-specific effect and industry-wide effects. Generally speaking, a standard MAC clause will exclude the effect of industry-wide conditions, except where it can be said that the specific industry-wide conditions disproportionately affected the company. And that circumstance was made out in the Delaware decision of Acorn. Now, another common feature that one sees in these MACs, and something important to keep in mind, is the distinction between a change that's historical versus one that's prospective. The basic clause will talk about a material adverse change in the financial condition of the company, but one that's even more favourable with the proponent of the clause will also focus on the prospects or its impact on future periods, and that's also often seen in M&A and agreements where the clause speaks of an event reasonably likely to have a material adverse effect. So even though the material adverse effect may not have manifested as at the point that the clause is relied on, if it can be shown that it's reasonably likely to have that effect in the future, then the clause will be engaged. Another important point in the cases is the distinction between qualitative versus quantitative measures of a material adverse change. Generally speaking, it's very difficult or it's harder to establish a qualitative MAC. These days, the better, or the MACs, or the ones, at least from the perspective of the party looking to rely on it, are more likely to be made out where there's a specific quantitative measure, as I've said, typically in terms of EBITDA, net asset, or some other financial trigger such as that. Now, I'll just briefly mention two other points before handing over to the others. Typically, a material adverse change clause will exclude particular effects, for example, pandemics or force majeure events. It will also often exclude changes in the law, legislation, regulations, or even generally accepted accounting principles. The idea here is that where the event is exogenous or external, the allocation of risk should sit with the buyer, whereas where the change is something internal, the risk should be borne by the seller. So the other important point to make is that where one often sees these clauses being upheld is where there is a provision or a statement to the effect that whether there's been a material adverse change will turn upon an opinion of the lender or proponent of the clause. And there are a couple of examples in the cases, including New South Wales Supreme Court decision Majeure in 2013, where in that case the clause was held to be made out because it turned upon the opinion of the lender, and the court was satisfied that that opinion had been honestly formed, and it couldn't be said that no reasonable person would have held that opinion. There was another prominent example in the 80s with the Woolworths Grace Brothers takeover, where again the clause turned upon an opinion of the buyer, and in that case the court held that it had been made out, the material adverse change. I would just footnote there that when we're talking about takeovers these days with Chapter 6, one has to bear in mind Section 629 of the Corporations Act, which would prohibit any clause that would vest in the buyer an opinion or discretion over whether there's been a material adverse change. I think at that point I will, Jeremy, I'll leave it there in terms of basic principles. We might come back to some other things as the discussion moves on.
Yes, great, thanks, Jonathan. I think maybe we'll segue now to force majeure and have Beverly tell us a little bit about the general concepts there. It seems to be some similarities in a sense in that a lot of it will depend on the drafting of the actual provision in question. But Beverly, do you want to just run us through the basic concepts of force majeure? I think you're on mute, Beverly. Sorry, I think. Sorry, I still can't hear you. I'm not sure, sorry. Can you hear me, Beverly? I can't hear you. I can't hear you, sorry. So what we might do, Andrew, do you want to just talk about frustration for a second, and we'll give Beverly time just to work out, maybe with Deborah's help, what's happening with the mute there.
Yes, of course. Thanks very much, Jeremy. Happy to do so. Good afternoon, everybody. Just a few brief introductory words on the doctrine of frustration. Unlike, of course, force majeure, which is a contractual, a creature of contract, doctrine of frustration occurs by operation of law. It's assessed objectively. It can only apply to events that occur after the contract has been agreed. And in general, it only applies where events take place that make the performance of the contract either impossible or illegal, or something radically different from that originally envisaged by the parties. So in that sense, it operates in a fairly narrow compass. And of course, much turns on construing the particular contract in question and what the nature of the performance is that is required under that contract, which is said to be frustrated. And those principles are long established over the last several decades. Now, how to address that then turns on a proper construction of the contract in question and its terms and obligations. This means that bright line tests as to what is a frustrating event and what is not are difficult to discern in isolation. So, for example, a global pandemic by itself may well not be a frustrating event, indeed quite likely is not. It all depends on what that impact has had on the performance that is the focus of the contract in question. It's not enough that a contract becomes more expensive or onerous than was originally contemplated. So, for example, it would not usually be sufficient that a party that had been let down by a supplier would therefore be able to claim frustration because they would be expected to source an alternative supplier, even if that was a hugely more expensive undertaking than had originally been envisaged at the time of contract. The doctrine does not apply where the matters relied on were the fault of one of the parties or the risk had been expressly or impliedly allocated under the terms of the relevant contract. So, for example, it won't apply to a risk that is eventuated where the parties had agreed an express force majeure clause which includes that risk. So in that sense, it operates something as a backstop rather than, and it can be displaced by the express terms of the contract. Where frustration does apply, it's got an important effect, which is the contract is automatically discharged as at that point in time. So in other words, any future performance that would otherwise have been required under the contract is released or cancelled. So for example, a partly completed contract to build and deliver an aircraft, the obligation to complete building the aircraft and to deliver it would be released. No doubt that's the subject of feverish review in Boeing at the moment. Obligations that have already become due, however, will survive, as will certain other clauses, such as choice of court and arbitration clauses that we'll be talking about later. Now, this automatic discharge occurs without the need for either party to take any further steps, such as sending a notice confirming that frustration has occurred, which is important. And of course, it is final. Once it's discharged, it's gone, unlike, say, force majeure, where the event giving rise to force majeure may be lifted and the suspension is temporary. Now, of course, the parties may have partly performed a contract before the frustrating event takes place. They may have paid deposits or made part payments or provided goods or services. Neither party is liable to the other under the contract as a matter. So it's a matter of the law of contract, but you need to consider unjust enrichment and frustrated contracts acts as they apply in the various states, which provide a path through for recovery of some of, or dealing with, what happens when a contract is frustrated mid performance, so to speak. Jeremy, I think that's probably a sufficient introduction to the issues. I wasn't proposing to say any more about framing it.
No, that's great. Thank you, Andrew. We might go to Beverly now to talk about force majeure.
Okay, can you hear me now?
Yes.
Awesome. Hi, everyone. So force majeure has in common with material adverse effect changes that they are concepts which are negotiated contractually as distinct from something which derives its force from common law, which means, of course, much like material adverse effect changes clauses, the provisions of a force majeure clause can vary from contract to contract, but they do have some common features, and the principal aim of them is in common, namely to address circumstances beyond a party's control that affect in a significant way parties' abilities to perform obligations. Some clauses, not all, but many, list examples of what a force majeure might be: acts of God, acts of war, terrorism, government action, labour shortages, machinery breakdowns, inability to obtain approvals, and in some cases relevantly express references to pandemics or epidemics. Where there isn't that express reference, there is some debate happening, particularly at the moment, about whether a reference to acts of God, for example, would encompass epidemics or pandemics. Acts of God tend to be understood to encompass natural disasters and weather-related emergencies. So the debates tend to center around whether a pandemic or an epidemic might be sufficiently natural or extraordinary or unforeseen to fall into that category as well. You can imagine, insofar as the test might be unforeseen, that it might well turn on when the contract was negotiated and entered into. You could be the subject of some criticism now, I think, for not having an express reference to a pandemic or an epidemic in your force majeure clause if you're intending to include it, as distinct from just relying on an act of God. There are some cases around that sort of natural component suggesting the fact that human-to-human transmission is required in order for a pandemic to arise, that might not be natural, for example. But generally the effect of the clauses are to relieve a party or both parties of obligations, and that requires a very careful reading of the contract to determine what obligations and in what manner they are affected. Some clauses refer to parties being prevented from performing, some talk about partial inability to perform, some refer to specific delays or deliverable-related impediments. One common issue arises around whether or not an obligation to pay money might be an obligation that can be affected by a force majeure clause. You do see clauses that expressly exclude these as obligations that might be affected by a force majeure clause. And there was a series of cases that arose after the GFC, emphasising that certainly economic downturns and changes in the availability of financing, for example, that led to contracts being significantly more expensive or onerous for payors, weren't provided any relief under force majeure clauses. And we can imagine some more cases along those lines emerging following obviously what's been happening at the moment. You get contractual regimes that specify very specific consequences. For example, rights, changes in rights or obligations for specific durations, revised obligations, revised pricing obligations. Some don't, however. I've talked obviously about variability of context from a common law perspective. Civil law jurisdictions will often have a force majeure concept at law. So it arose consistently with perhaps the name as part of French civil law. And there are many other countries which include a force majeure concept within their civil law, China being one, for example. And you can imagine that the jurisprudence in those particular countries might well have some more consistent principles that can bear on interpretation more generally and might well arise in an international arbitration context. Again, that's probably all I really need to say by way of general introduction.
Yep, thank you, Beverly. We haven't had any questions come through. I might just make a couple of observations which I'll float maybe as ideas, and we can pick them up at the end of the discussion when we talk about the suitability of these types of disputes for resolution by arbitration. The first is, it seems to a large extent there's arguably limited value in precedent for a lot of these decisions when it comes down to assessing what is material, unless there's a very prescriptive clause, or whether a contract's been frustrated. Certainly, there will be a large element of judgment that will be applied, and perhaps that means the ability to select your tribunal in an arbitration context is very powerful power. The other thing that occurred to me, Andrew mentioned that no notice is often required for frustration. It just happens. And I know from experience, some FM provisions do provide for notices to be provided within a certain amount of time or a reasonable time. Some are silent. And I suppose there's a question with the current COVID situation, whether even if FM notices and frustration notices haven't been issued, it's still that risk is still sitting there for a lot of contractual parties, and may crystallise later when everyone's got a bit of a better lie of the land and how things are going to play out. But I think I'll park that for now. I'm just conscious of time and make sure we get through the full presentation. So the next section we're going to talk about, following roughly the same structure, is just where are we actually seeing these issues at the moment with the COVID-19 situation. And Jonathan, we thought we might start with you to talk about material adverse effect or material adverse condition provisions, and how that has come to the forefront in the current situation. Sorry, Jonathan, I think you're on mute. Sorry.
Thank you. Sorry. I was saying in terms of the coverage of these clauses, MAC clauses are obviously very common in M&A agreements, and that itself embraces a very wide range of transactions, from public takeover offers, schemes of arrangement, share purchase agreements, asset purchase agreements, private equity investments, joint venture agreements, and so on. So that itself covers a very broad range of commercial contracts. It also is very common, of course, in lending facilities, and often the two are intertwined because the acquisition financing is through, for the particular M&A transaction, is through a lending facility. So they're universal in financing arrangements, and related to that, on the other side, underwriting agreements for floats and share offerings and so on, and project finance agreements. So the basic point is that M&A clauses are prolific across the spectrum of commercial contracts, and there is nothing particularly unique about them to a particular industry. They apply to all industries. So that's just a preliminary observation in terms of the coverage of these type of clauses. Now, obviously, what we're seeing at the moment is that particular industries such as tourism, hotel, hospitality, aviation have been particularly badly affected. And within those industries, certain companies have been more severely affected depending upon their particular circumstance or their access to supply, distribution channels, and even, of course, their particular exposure to a certain geography. At a general level, though, again, as I've said, the industry effects alone are not sufficient. You need to point to something specific, but of the impact of the event on an industry will be felt more specifically by particular companies because of, for example, higher leverage, greater productivity constraints, particular difficulties in access to supply, particular IP issues, or, as I said, particular exposure to geographies that are badly affected. There has not been, prior to COVID-19, insofar as I'm aware, any reported or litigated instance of a MAC being engaged by reason of a pandemic. However, at least in the press in the last few months, there have been a couple of examples of companies relying upon MAC clauses to get out of a deal. One example was the Centura Capital Group that withdrew its $180 million offer to buy a New Zealand property fund, relying upon a MAC clause. Another example was a $300 million transaction involving Abano Healthcare, and that involved a business investing in a dentist chain. And as a result of the lockdown for 4 weeks, it was asserted that the MAC had been engaged and the deal with the private equity firm was withdrawn, although I'm not aware of that going to litigation. There's also another high-profile example in England where a major public takeover was withdrawn, was purported to be withdrawn on account of a material adverse change clause, but the UK Takeovers Panel issued a ruling that the reliance on the MAC clause in that particular case was not justified, and that followed a very conservative view that the Takeovers Panel has taken historically of MAC clauses, where they've said, and I quote, "It will usually require very considerable significance striking at the heart of the purpose of the transaction, something that would justify frustration of a legal contract." So that was a particularly strict view that the UK Takeovers Panel has taken. But in terms of the effect of the pandemic, one thing to bear in mind here, of course, as I said earlier, is the duration of significance. And even though the immediate, if you like, event or effect, or if you like, the trigger, might be only a month or two or a little bit longer, it'll be careful, of course, it'll be important, of course, to look at how that will translate into any serious long-term consequences. So the fact, of course, that, if you like, restrictions have been eased and there's a return to normality, and that if you like, the lockdown has only lasted for, a somewhat short period of time, in and of itself does not mean that a MAC clause in particular circumstances won't have been engaged. The other issue, of course, will be foreseeability. And again, this will turn on the facts and circumstances of the company and the jurisdiction in which it's located. One can imagine, of course, that the operation of a MAC and what was foreseeable might be different in the case of, say, a Hong Kong company in light of SARS and exposure to pandemics versus an Australian company where there have been no recent instances of pandemics. And obviously, as Beverly said, going forward in contracts that are entered into, foreseeability issues will loom large. So, Jeremy, that, just by way of general observation, that was all I had for the moment on the impact of COVID and on MAC clauses.
That's great. Thanks, Jonathan. It's interesting that the examples that you raised were all M&A type transactions and not financing. And I understand anecdotally, at least from the Alan Linklater's network, that as far as financing transactions are concerned, a lot of this came to the forefront in the GFC, and as a consequence, a lot of provisions are now amended with with defaults arising by by way of certain ratios not being met, and it may be that now that's what the finance sector are relying on rather than MAE, and maybe now in the M&A transactions to come, people will be looking more closely at the provisions in M&A documents as well. It's interesting.
Yeah.
Beverly, did you want to run us through what we're seeing in relation to force majeure?
So I probably less so in loan and financing agreements, I suspect, because of the constraints around, or the general principles around paying of money being the sort of obligation which is not likely to be affected by force majeure. Equally, in an M&A context, you can possibly see some issues arising between perhaps execution and completion. But really, where force majeure clauses are going to come into their own are going to be in agreements with more sustained operations, so construction contracts, manufacturing contracts, sales of goods and services. Certainly, if you're looking at a cross-border contract relating to the sales of goods, you want to think about Article 79 of the Vienna Convention, which if it applies, includes what it describes as an impediments clause, but sounds very much like a force majeure clause. Industry and sector-wise, similar to those previously mentioned, aviation, tourism, construction, anywhere where there's restricted movements that affect labour to support manufacturing operations or mining operations, for example. Anecdotally, I mean, we're seeing a few, but anecdotally, certainly at the moment, there seems to be an acceptance that these issues are affecting people broadly and almost an agreement to share the pain. And so it'll be interesting to see how this and when this changes. For example, one might imagine that when some of the government assistance packages in Australia, for example, run out in a few months, whether some of the agreements around sharing the pain get less agreeable, if you like. And that might well then cause some issues around the triggering of notices. So force majeure clauses can often, much like MAE clauses, will often have obligations for parties to give notice of what the force majeure event is, and including some specifications around duration, effect on obligations. And there might really be some issues around compliance with that, where parties have agreed not to invoke it or just tacitly not invoked it. And even if they haven't, or even if you haven't, there might well be some issues around what is the event that triggers the clause. So, you know, the World Health Organization declared a public health emergency on the 31st of January. They declared a pandemic on the 11th of March. The Australian government banned gatherings of 500 people on the 15th of March. It banned international travel on the 17th of March. States and territories have closed their borders on different dates as well. On a cross-border contract, you might need to look also at what corresponding governments have done. For example, I know there have been some issues with projects in Australia relating to a slowdown in manufacturing in China as far back as January and February, for example. So real issues arising in those contexts about what is the triggering event and whether or not notice needs to be given. That's probably enough from me on those issues.
Yeah, thank you, Beverly. I might just jump to Andrew to talk a little about frustration and what we're seeing in the market.
Sure, thanks, Jeremy. I just briefly, given time, I think in frustration, because it has a narrower compass in some senses than some of the others, potential issues we've been talking about, it really comes into play in circumstances where you have what is now fundamentally a bad bargain. And of course, the debate between the parties is typically whether the bargain was bad before the frustrating event and an attempt is being made to simply get out of the contract, or whether the frustrating event was what gave rise to it being a bad bargain, in the sense of it's either impossible or illegal or substantially different to perform. I think in circumstances where this tends to play out, certainly we're aware of some construction projects where the workforce was almost entirely foreign, and the border closures and restrictions have meant that that workforce has been excluded from the relevant country, and there is certainly an argument, a pretty decent argument, that has given rise to a frustrating event, particularly as border closures have carried on. So those issues are playing out. It tends to come up, I think, where you might have performance being time of the essence. So if some of the recent either border closures or other impacts of the pandemic mean that the timing of performance can no longer be given, and that was of essence, then that's an argument. There will be, in certain, for hotel agreements and other tourism-related agreements that may have been in place beforehand, before the pandemic really took off, that could be a factor. Where there is a failure of a specific source of supply, something of that nature, then if an alternative cannot be found, then of course, either because that supply was unique in the sense of a particular consultancy or a particular business from one part of the world and can no longer be delivered, then of course that would be relevant. But I think typically at the moment, most of the frustration cases are the consequences of it being made illegal to travel for foreigners, and that is having an impact and leading to certain arguments. But where those arguments are playing out, that typically longer term projects, which therefore we need to look at the timetable and find out whether they're irredeemably hold below the waterline or can be remediated in some way. And so those issues are under discussion. And otherwise, where it might be someone just contracted for the supply, for example, airlines contracting for a certain amount of avgas over the next 12 months, and of course that's no longer required for a reason that's got nothing to do with the contract. There are those types of issues we know are also playing out in the oil markets. That's probably enough, Jeremy.
Yeah, thank you, Andrew. And it's interesting, the mobility of the workforce is something we're certainly seeing in the Western Australian market having an impact on mining operations and other operations. Just the inability to travel interstate has had an incredible impact, and there are certainly force majeure issues, and whether or not people start claiming frustration as well, I suppose, is yet to be seen. In the time remaining, we'll just swing around and pull all that together now and look at it through a bit of an international arbitration lens. And interested to hear the speaker's thoughts on just observations on these particular issues from an arbitration perspective, and also the advantages of arbitrating these types of disputes. So perhaps we follow the same order that we've used throughout. Jonathan, did you want to give your observations on material adverse event clauses, or just generally,
Yeah, sure. Sure. I mean, the first general point to make, of course, is that it's not uncommon to see all three of these concepts litigated at the same time and being pressed, as alternatives. There was one prominent example in 2010 involving the takeovers panel, NGM Resources case, where the takeovers panel was asked to look at whether there'd been a force majeure or a material adverse change. So again, that's just a general point, that because the facts can intersect into all three concepts, it's not uncommon to see all of them or more than one of them in play. The other, in terms of MAC clauses themselves, I mean, again, many of them involve cross-border contracts, so the usual advantages of arbitration in respect of cross-border contracts, including, of course, relative ease of enforcement, apply equally. Again, because we are dealing fundamentally with issues of contractual interpretation, they are inherently arbitrable, and there's no per se reason why they can't be arbitrated. Focusing then on some of the reasons why, in particular circumstances, it might be desirable to arbitrate it rather than litigate it in a court, but quite apart from whether it's cross-border. Of course, speed and flexibility is a virtue of arbitration, and in many cases, obviously in the case of a MAC clause, speed really is of the essence, and having it resolved quickly. Obviously, courts, particularly New South Wales Supreme Court or Australian courts generally, can deal with these types of disputes very efficiently, but arbitration obviously also offers that advantage. And as you'll all be aware, or you should be aware, ACICA has emergency rules that can deal with things even more quickly. And again, a particular advantage is the parties can design and tailor the process to suit their needs. So, for example, some of the instances where we've seen MAC clauses arise have been through the takeover panel process. And of course, the takeovers panel was set up in particular to provide for outcomes that are more speedy and more flexible. Well, there's no reason why processes, in arbitration could not mimic a takeovers panel style process if that's what the parties wanted in order to determine a particular M&A, a particular MAC clause in an M&A context. Another important consideration is confidentiality. Because the impact can be so profound, and even the assertion of a material adverse change clause by a lender against a borrower can have devastating reputational consequences. There are particular advantages in this context in having the matter determined quickly and privately through arbitration. I think you've made a very good point, Jeremy, that it is all very fact specific and subjective, and involve a particular understanding of an industry. So in that regard, the ability to select an arbitrator or panel that's equipped and experienced to assess the relative magnitude of the event within the industry is a particular advantage. I think in terms of the evidentiary process, there may well be other advantages just in terms of getting it all assembled quickly, but I don't think those are sort of particularly significant compared to how modern commercial courts can operate in an urgent setting. But overall, I think certainly there are many features of these types of disputes concerning MACs that make them attractive to be arbitrated. And again, if it involves something cross-border, it's virtually a no-brainer not to arbitrate it.
Yep, thank you, Jonathan. Beverly, did you want to give your perspective on things?
Yeah, I think Jonathan's covered them as they would similarly apply in a force majeure context. Contractual disputes of this nature are commonly arbitrated. The speed and flexibility are the essential, particularly when you are talking about an agreement with sustained operation and ongoing supply obligations, for example. And equally, confidentiality could well be tremendously important to parties where you are talking about a critical impact on someone's business and someone's ability to perform. They're not usually things that one wants played out in a public forum. And then the same considerations also apply as to being able to select a tribunal that can deal with those sorts of things quickly, flexibly, and with knowledge of the relevant industry. So I think similar consideration.
And Andrew, would you like to add your perspective on these things?
Yeah, look, just thanks, Jeremy. Just briefly, because I think the other panelists have largely covered it. I think when it comes to the speed question, there's no doubt that looking at a frustration question or an FM question or a MAC question, that all parties want an answer to that quickly as to whether it is good or not. And that is driving some interesting behaviours. So certainly in some of the matters I'm currently dealing with, there is a desire to get before a decision maker extremely quickly. If the dispute resolution clause in the contract hasn't got, say, a reference to an arbitration institution with emergency or expedited procedures, then that is causing genuine difficulties. The parties are either having to agree a bespoke arrangement or try and head to court, get in quickly. The concern about going to court is A, confidentiality, and B, an appeals process on some of the big ticket matters. And certainly in some areas around frustration, there is clearly the law is ripe for another run through the higher courts. And so I think there are parties who are thinking, well, we could be before a court more quickly, but the ultimate long game might be a slower one versus taking longer to get started, in the meantime being at risk of being in breach in circumstance or repudiating a contract in circumstances where otherwise would want to know that quickly. So those issues are playing out. I think that case specific. I think you're quite right. Anything to do with long-term with cross-border contracts, particularly say in Indonesia, the courts are largely closed. So you'd want to be agreeing arbitration as quickly as possible, which at least is moving. The Australian courts have been very efficient at getting back on track and pushing through things, and indeed have streamlined their procedure to deal with some of the issues that have arisen through social distancing and travel bans. But those issues they are the critical ones, I think, around speed and finality and confidentiality.
And as far as expert evidence is required in these types of proceedings, do you think there's any distinguishing features of arbitration and how that might be managed in arbitration context as opposed to in the court process? I can see, for instance, in the material adverse change type dispute, you'd need industry experts to potentially to be assisting the tribunal about whether something is material or not, or whether it's industry wide. Are there any pros or cons of arbitration that any of the panelists see in that regard?
Look, I think again, the modern Australian courts are very effective at this. I mean, there would have been a time, I think, not so long ago, where I would have said the advantages of perhaps hot tubbing of concurrent evidence and the capacity to deal with it more efficiently and quickly in that regard might offer a particular advantage, but Australian courts are well equipped and used to using that type of process to deal with expert evidence. So, I mean, I think apart from the general relative informality and less strict reliance on expert evidence principles and objections and so on, I think I wouldn't for myself, I wouldn't see that as a particular advantage or distinct advantage of arbitration, but others might have a different view.
I'd just add that I think there are a couple of practical issues playing out. One is, of course, experts who are not in the relevant jurisdiction and having them give their evidence or potentially be cross-examined over remotely. And there are lots of different protocols in place for how that is dealt with, but I think everybody is adjusting to the realities of that, and expert evidence is easier to do that than it is, say, a fact witness where there's an issue of credibility at stake. I think there are, one particularly noticeable thing I've found recently is that there are experts. If you're stray outside a defined discipline of expertise, then of course you're immediately met with some admissibility objections within the court process that you wouldn't get in the arbitral process. And so there is some streamlining being done in that regard. I think that's worth bearing in mind. So yeah, my note of caution on all of this would be you should, where possible, if you're representing a party or you are a party, you want to pick the most favourable forum for the issue that you face. And that may or may not be court or arbitration, depending on the specific factors at issue.
Sure. Thank you, Andrew. Beverly, did you have any observations you wanted to add either on that point or anything else?
No, not really, other than I find experts prefer arbitration because if they're wrong, then it will all be much less public. But I'm not sure that should be a prevailing factor.
Okay.
I suppose the only other thing, I mean, again, others might have a different experience, but as a general observation, I think there's a greater inclination for a tribunal to appoint a tribunal expert in arbitration than perhaps courts. It has happened, but that's perhaps less common, and that can, when done effectively, can result in significant efficiencies.
Yeah.
So,
Well, great, thank you. I'm just conscious of time. We're right on the hour. Was there anything else that any of the panelists wanted to raise before we close? Or any other comments or anything? Jonathan, or Beverly, or Andrew?
Nothing from me.
Yep.
Okay. Nothing from me, other than to say, obviously, I would just, putting on my ACICA hat, just encourage everyone in the dispute resolution arena to remind themselves of the ACICA rules and the advantages that arbitration might offer in particular circumstances in this environment generally, and in the context of the types of issues we've been talking about.
Yeah, absolutely. I agree with that, and I think there's a lot of commercial people out there who are now taking a lot closer look at clauses that they may not have paid a lot of attention to previously, and I think there's a real opportunity to promote arbitration to the extent that it wouldn't have actually been used. So I totally agree with that, Jonathan. Well, thank you, everybody. Thanks to all of the panelists, Jonathan, Beverly and Andrew, for your time. It was very engaging discussion. Thank you for all the attendees. We haven't had any questions come through, but thank you all for attending. Before I close, I'll just do a bit of a plug for the next ACICA COVID series webinar, which is on 24 June, and that's on interim measures. So join that if you can. Okay, thank you very much, everybody. Enjoy the rest of your day.
Thank you. Bye.
Bye.